I'm standing outside the Royal Courts of Justice today, where we have just heard Oceana outline its case against 31 oil and gas licences which were granted under the Tory government as well as It argues that the environmental impact assessments for these oil and gas projects were conducted unlawfully on the basis that they did not take into account downstream or Scope 3 emissions, and on the basis that the Habitats Directive protects local marine life.
We're Oceana. We're here at the Royal Courts of Justice to challenge the oil and gas licensing process undertaken by the government. We believe that those licences, the most recent round of licences, were issued with unlawful environmental assessments that didn't include the impacts of climate change, didn't consider accidents and oil pollution spills, ignored the advice of the government's own nature advisors. So we think we've got a really strong case, and we'll be here for the next 2 days to do it.
The best outcome we could hope for today is sense. I mean, we've got sense and we've got essentially the law on our side. The process of granting these licences was unlawful. That's what we assert. It was granted at a time when the government were acting rashly. They weren't, going through the proper protocols. They were trying to achieve things very quickly. I took a case against the previous government over net zero, and their calculations, well, there were no calculations. Their decisions were taken in the moment of populist politics. I've subsequently and successfully negotiated that case with the contemporary government, and they were very pleased to do so. They saw sense there. What we want here is justice and sense to be seen, to send a clear message to the oil and gas industry, and that is that you have to change. And if you don't, you're going to kill our one and only home law.